Donald Trump has just threatened to sue Trevor Noah, not for an investigative report, not for leaked documents, not for a breaking news accusation, for a joke. A 30-second line delivered on the Grammy Awards stage about Jeffrey Epstein's island, and if that sounds trivial, if it sounds like another Trump outburst you can safely ignore, you are missing what's actually happening here, because this threat is not about Trevor Noah, it's not even about comedy. It's about power, speech, and the deliberate weaponization of defamation law to intimidate critics into silence. From a prosecutor's perspective, this move is not just aggressive, it is reckless. And if Trump follows through, it could open legal doors he has spent years desperately trying to keep closed. To understand why, you have to start with the moment itself, the joke that sparked the fire, Sunday night, February 1st, 2026, the Grammy Awards. Trevor Noah is hosting for the fifth and final time. The mood is light. The room is filled with artists, executives, cameras, and millions of viewers who understand exactly what kind of event this is. Entertainment. Billie Eilish wins Song of the Year for Wildflower. Applause, celebration. Then Noah delivers a line that lasts less than 30 seconds. He jokes that the Grammy is the award every artist wants almost as much as Trump wants Greenland. Why Greenland? Because Epstein's island is gone and Trump needs a new place to hang out with Bill Clinton. The audience laughs. Noah follows it with a wink to the crowd. I told you it's my last year. What are you going to do about it? That's it. No accusation, no allegation, no claim of fact, a joke delivered in a room full of people who understood exactly what it was. But by 10:01 a.m. the next morning, Donald Trump is furious. Trump's Truth Social threat. Trump doesn't post a quick denial. He doesn't shrug it off. He doesn't laugh it away. He writes a nearly 300-word post on Truth Social. He accuses Noah of falsely claiming that Trump spent time on Epstein's island. He insists he has never been there, never been near it, and had never even been accused of going there. Not by fake news media or anyone else. Then the threat escalates. Noah is called a total loser, a talentless dope. Trump says he'll send his lawyers. He references past settlements. He tells Noah to get ready. He says he's going to have some fun. This isn't off-the-cuff rage. This is a calculated threat, and Trump feels emboldened. Why? Because recently his legal team has extracted multi-million-dollar settlements from major media organizations. ABC News paid $15 million after George Stephanopoulos misstated a legal verdict. CBS paid millions more over a disputed interview edit. Trump sees those settlements as proof of strength. But here's the critical mistake. Those cases were nothing like this one. Why? This case is different and dangerous for Trump. Trump is treating Trevor Noah like ABC or CBS. That's the first error. Noah is not a journalist making a factual claim. He's a comedian delivering satire at an awards show. And under American law, satire sits at the very top of First Amendment protection. But there's a second, far more dangerous error, one Trump's lawyers should have flagged immediately. 3 days before the Grammys, on January 30th, Trump's own Department of Justice released over 3 million pages of Jeffrey Epstein files under the Epstein Files Transparency Act. The Deputy Attorney General stood at a podium and declared full compliance. And buried inside those documents, Donald Trump's name appears more than 3,000 times. Emails, photographs, flight logs, witness testimony. That context changes everything. Because once you threaten to sue someone over an Epstein joke, you invite the courts to examine your relationship with Epstein in forensic detail. And that is the last place Trump wants to be. What the Epstein files actually contain. Let's be precise here. Donald Trump has never been charged with a crime related to Jeffrey Epstein. Neither has Bill Clinton. Both deny knowing about Epstein's criminal conduct. But the files released by Trump's DOJ contain information that directly contradicts Trump's claim that he has never been connected to Epstein's properties or activities. They include photographs of Trump at Epstein's Manhattan townhouse, flight records indicating Trump traveled on Epstein's private jet more times than previously known, testimony from a victim stating Ghislaine Maxwell suggested availability for Trump and his associates, statements from Trump's own Mar-a-Lago employees describing frequent social interaction between Trump and Epstein. Internal DOJ communications acknowledging Trump's repeated presence in Epstein-related investigations. Again, none of this proves criminal wrongdoing, but it absolutely proves connection. And in defamation law, connection matters. Why Trump's lawsuit threat is legally weak to win a defamation case, Trump must prove 4 things. A false statement about Trump published to others that caused reputational harm, but because Trump is a public official, there's a 5th requirement, actual malice. Under New York Times versus Sullivan, Trump must prove that Trevor Noah either knew the statement was false or recklessly disregarded whether it was true. And here's the fatal flaw. You cannot prove actual malice for a joke that no reasonable person interprets as a factual claim. That principle was settled decades ago. Hustler versus Falwell, the Supreme Court speaks. In 1988, the Supreme Court decided a case that still quietly governs the boundaries of satire, power, and free speech in America. Hustler magazine versus Falwell. At the center of the dispute was a deliberately outrageous parody. Hustler magazine published a fake advertisement implying that televangelist Jerry Falwell had engaged in an incestuous encounter with his mother. It was crude, offensive, and designed to shock. Falwell was furious, and he sued, arguing that the parody had defamed him and caused emotional distress. The Supreme Court did not hesitate. In a unanimous decision, it ruled against Falwell. The reasoning was not subtle, and it has aged remarkably well. The court held that satire, even deeply offensive, even outrageous satire, is protected speech when no reasonable person would interpret it as stating actual facts. The parody was not presented as journalism. It was not framed as an investigative claim. It was exaggerated to the point of absurdity, and that absurdity was the point. Chief Justice William Rehnquist, writing for the court, made the broader danger explicit. If public figures could sue successfully over parody simply because it humiliated or offended them, then political satire itself would become impossible. Cartoonists, comedians, writers, and critics would be crushed under the weight of lawsuits from powerful figures eager to silence mockery. The First Amendment, the court concluded, does not exist to protect polite speech. It exists to protect speech that power finds uncomfortable. That principle is the foundation. Now apply that logic to the present. A comedian standing on the Grammy stage delivering a joke about Epstein's island is not issuing a sworn affidavit. They are not presenting evidence. They are not making a factual claim meant to be believed as literal truth. They are doing exactly what satire has always done, referencing a widely known cultural scandal and exaggerating it for effect. The joke relies on shared public awareness, not secret knowledge. It trades in implication, not assertion. Crucially, the audience reaction matters. In Hustler versus Falwell, the court emphasized the perspective of a reasonable person. Would a reasonable person believe the parody was stating actual facts? In the case of a comedian's joke, the answer is clearly no. The laughter of the audience itself becomes evidence. Laughter signals understanding. It signals recognition of exaggeration, irony, and absurdity. People laugh because they know it is not a literal claim. It is a joke built on cultural shorthand. This is not a minor detail. It is central to the legal standard. For a defamation or false statement claimed to succeed, Trump would need to show that the statement was presented as fact, that it was false, that it caused harm, and that it was made with the required level of fault, actual malice, given his status as a public figure. Satire collapses that framework at the first step. When speech is clearly comedic, clearly exaggerated, and clearly understood as such, it fails to qualify as a factual assertion at all. The Supreme Court anticipated exactly this scenario decades ago. Rehnquist warned that without protection for satire, public discourse would be sterilized. Powerful figures would not need to prove falsity or harm. They would simply sue until critics back down. The law draws a hard line to prevent that outcome. That line protects speech people dislike. It protects speech that embarrasses. It even protects speech that feels unfair. What it does not protect is knowingly false statements of fact presented as truth. A joke on an award show does not come close to that threshold. This is why Trump cannot meet the legal standard. His claim would fail not because courts endorse the joke's content, but because courts protect the form. Satire lives in exaggeration. Comedy lives in implication. The legal system recognizes that difference because it must. Without that recognition, every punchline aimed upward would become a legal risk. The irony is that this protection exists precisely because figures like Falwell and later Trump attempted to weaponize the courts against ridicule. The Supreme Court shut that door firmly in 1988, and it has never reopened it. The law does not require satire to be kind, respectful, or balanced. It requires only that no reasonable person would mistake it for a factual claim. In this case, the laughter already answers that question. The real purpose of the threat. So why make the threat at all? Because Trump does not use litigation the way most people do. He is not primarily interested in winning cases on the merits. He uses lawsuits as a weapon of intimidation. The goal is not a courtroom victory, it's a chilling effect. The mere possibility of legal action is often enough to reshape behavior, silence critics, and inject hesitation where confidence once existed. This strategy has worked for him before. Media companies understand the math. Defending a First Amendment case, even a strong one, is expensive, time-consuming, and unpredictable. Legal teams bill relentlessly. Executives are distracted. Advertisers get nervous. Share prices wobble. Even when the law is clearly on the defendant's side, the process itself becomes the punishment. Settlements in that context are not admissions of guilt. They are business decisions. That's why ABC and CBS settled, not because they believed they were clearly wrong, but because prolonged litigation carries costs that have nothing to do with truth or constitutional principle. Writing a check is often cheaper than spending years defending speech that, while protected, still attracts controversy. Trump understands this dynamic intimately. He exploits it. The message he wants to send is not subtle. Mention my name next to Epstein's and you will pay for it. If not in court, then in time, money, and stress. He wants comedians, journalists, producers, and network lawyers to pause before greenlighting jokes, segments, or investigations. Not silence, just hesitation. That half second of doubt is the chilling effect at work. But here is where the strategy breaks down. Trump is misreading his target. Trevor Noah is not a network executive managing shareholder pressure and advertiser relationships. He is not a corporate brand trying to protect a fragile revenue stream. He is a comedian at the end of a hosting run with a global audience, a personal brand already established, and no institutional leash. He said it plainly, almost dismissively. What are you going to do about it? That question matters because it exposes the weakness of the threat. Trevor Noah has nothing to lose in the way Trump's previous targets did. No board to answer to, no quarterly earnings call, no advertisers threatening to pull funding. If anything, a lawsuit only amplifies his platform. For a comedian, attention is not a liability, it's oxygen. The intimidation model collapses when the defendant does not fear the process. And then there is the deeper problem for Trump, one that far outweighs any chilling effect he hopes to create. If Trump actually files this lawsuit, he triggers the one thing that terrifies every defendant who truly understands the law: discovery. Discovery is where intimidation strategies go to die. Once a lawsuit is filed, Trump loses control of the narrative. The case stops being about a joke and starts being about evidence, depositions, subpoenas, document requests, communications, timelines, who knew what, when, and why. Every claim Trump makes opens the door to questions he cannot selectively answer. Every allegation invites scrutiny, not just of the joke, but of his own conduct, associations, and history. This is why so many powerful figures threaten lawsuits but never follow through. Filing means surrendering to a process that does not respect bluster or branding. Courts do not care about political grievance. They care about facts, relevance, and procedure. And once discovery begins, defendants are allowed to explore anything reasonably related to the claims at issue. In this context, that is dangerous territory. Trump would have to establish that the joke implied a false statement of fact about him. That alone invites examination of what facts already exist in the public record, what associations are documented, and what communications have been disclosed in prior cases. Even if none of that results in liability, which is likely, it still becomes part of the legal process. It becomes searchable, citable, discussed under oath. For someone trying to suppress association, discovery does the opposite. It hardens it. This is the paradox at the heart of Trump's legal threat. The intimidation works only as long as it remains theoretical. The moment it becomes real, the leverage flips. The defendant gains procedural rights, the press gains documents, the public gains transcripts. What began as an attempt to silence a joke becomes a spotlight aimed directly at the very topic Trump wants buried. That is why this lawsuit almost certainly remains a threat and nothing more. Its power lies in fear, not execution. Against corporations, that fear has teeth. Against a comedian with nothing to lose and every incentive to fight, it evaporates. And Trump knows that, which leaves the threat exposed for what it is, not a serious legal maneuver, but a warning shot meant for others watching. The problem is that once one person refuses to flinch, the warning loses its force. Intimidation only works when people believe the consequences will be worse than the fight. In this case, they won't be. Discovery. Discovery is where lawsuits become dangerous, because discovery allows the defendant to demand documents, emails, phone records, depositions, and sworn testimony. If Trump sues Noah, Noah's lawyers can subpoena every communication Trump had with Epstein, flight logs, calendars, and travel records, emails and texts involving Epstein or Maxwell, depositions of Mar-a-Lago staff. Testimony from witnesses named in DOJ files. Trump himself would likely be deposed under oath, hours, possibly days. Every denial would be subject to impeachment with documents already released by Trump's own DOJ. From a prosecutorial standpoint, that is madness. No competent legal strategy invites discovery on your most vulnerable issue unless you absolutely have to, which tells us something important. This threat is not about winning. It's about message control, narrative warfare, not law. Look at the timing. The DOJ releases Epstein files. Democrats immediately accuse the administration of withholding millions of pages. Oversight hearings loom. Questions multiply. Then a comedian makes a joke. Trump seizes the opportunity to flip the script. Suddenly, he's the victim of false accusations. Suddenly, the conversation shifts from transparency to defamation. It's narrative warfare. But here's the irony. Trump's threat has done the opposite of what he intended. Millions of people are now Googling Trump Epstein files. The Streisand effect is in full force. Every attempt to silence speech draws more attention to the underlying facts. Why this matters beyond Trump and Noah. This case isn't about personalities, it's about precedent. If powerful officials can threaten comedians into silence through litigation, intimidation, the First Amendment becomes conditional. The Supreme Court warned about this in 1964. Justice Brennan wrote that democracy requires breathing space for criticism, even harsh, inaccurate, or uncomfortable criticism. Without that breathing space, fear replaces accountability. Trump's strategy exploits the gap between legal theory and practical reality. Yes, Noah would likely win, but the process itself becomes punishment unless the target refuses to blink. And Trevor Noah may be the worst possible person to test this strategy against. If Trump files this lawsuit, he will almost certainly lose. But he may expose himself to sworn testimony, document production, and scrutiny that far outweigh any reputational benefit. If he doesn't file it, the threat alone still chills speech, but it also signals weakness. Either way, the courts, not Truth Social, will decide. And history is clear on this point. Satire is protected. Criticism is protected. Power does not get to silence laughter. The real question now isn't whether Trump will sue. It's whether this moment becomes another reaffirmation of the First Amendment or another warning sign that powerful figures are willing to test its limits. Stay alert, because when jokes start triggering lawsuits, democracy is already under stress.